Yes.
Thank you, Lordship. I beg to pay for listing of an petition of 7th of May, my lord.
It's pending or
Pending for admission.
Service is complete.
My lord, both the parties have appeared, and in the month of March it was listed, and it was fixed for admission.
My lord. My lord, item number 17, my lord. 17. This item may be listed on tomorrow
Why?
in admission hall.
Why not today?
Today, leading counsel. So I'm on behalf of BP Chair, Lordship. Today he has some.
What is the fight between both of you? Are you aware? Then Monday.
Monday. All right.
Monday.
May I please, my lord? My lord, I beg to mention item number 10.
Yes.
The conducting council is out of this station, so kindly madam may be adjourned for the time.
Content adjournment.
Yes, sir.
When?
On May 7th, next week.
Next week.
DB office.
Lordship, I beg to mention item number 8. I'm here on behalf of the council for the respondent. The council is sick as of today, so kindly this matter may be released after 3 weeks.
3 weeks.
3 weeks.
Lordship, I'm for the
Item
petitioner.
8. Huh?
I'm for the petitioner, Lordship.
In item 8?
Yes.
Okay.
Lordship, so date may be given because it is a case of 2016, Lordship.
Okay.
Yeah.
Give a date. Not 3 weeks, then give a date.
1 week, Lordship.
When? Give a consensus date, both of you.
Two weeks.
2 weeks.
Hmm.
After 2 weeks, give a date. 14.
Okay. Deeply obliged.
I would like to mention item number 9.
Yes.
Matter may be taken up after 3 weeks, Lordship.
Huh?
After 3 weeks, Lordship.
3 weeks.
Interim order is there.
Interim order, passer will continue till then.
Thank you very much.
We thought of allowing this petition. You appreciate also. Yes.
I beg to mention item number 21.
21.
The learned council also is out of station. So kindly matter may be adjourned for today. The matter may be fixed on 27th of May.
27. On the prayer of learned council for the respondent. Yes.
Lordship, I beg to mention item number 7. I'm appearing for the respondent number 2 and 3.
Your Lordship, I'm for the petitioner on
Yes.
behalf of LSO.
You want an adjournment?
Yes.
When?
Matter fixed after 3 weeks.
Huh?
3 weeks.
3 weeks.
Respondent. 2 and 3.
Respondent. They are enjoying a stay.
You know, there is no any stay.
Okay.
No stay.
On the prayer of the learned council for the respondent number.
Yes, 7.
Private
2 and 3.
private respondent. Stress informant. Matter stands adjourned and be listed after 3 weeks.
Much
obliged.
I beg to mention an unlisted matter.
What is
So
the
which-
issue?
Unlisted.
Unlisted, what is the subject matter? Writ petition, criminal petition?
Yes, SAO.
Huh?
SAO. SAO.
Second appeal against the order. What is the subject matter? When the order was passed?
Lordship, actually, I have not been acquainted with the
That
subject.
you must be acquainted before we're having an unlisted. Generally, you don't give unlisted. Tomorrow,
Day after tomorrow.
day after tomorrow. Give the book. Proviso 3, isn't it?
Yes.
Proviso 3, there is a judgment, this is, you have filed, what you have filed? You have filed a petition, CRP,
Sure.
your limitation was, delay was not condoned.
Yes.
So, it was before
Civil Judge Junior Division.
Civil Judge Junior Division. So it will be second appeal.
Yes.
Now you have filed it, what revision?
There is no second appeal provision in the act.
Not act, but if it is an appeal, I think there is a judgment of my Lord Justice Debashish Barua on this point.
On delay matter.
Not on delay. On delay generally, so far relating to when there is an appeal. Forget about this provision. A decree passed by an appellate court, if the appellate court dismisses the appeal on the ground of delay, Supreme Court says
Yes, second.
it will be second appeal. Now, what will happen in this case? So it is an appeal to a civil court. Civil court has not entertained the appeal for delay. Now, whether it will be second appeal and revision. That is what I want to know.
Supreme
There-
Court in normal case, it has to be second appeal.
It is to be second appeal, but there is a twist because the against the order of the customary court, the proviso 3 to the amended provision of section 15. It says that it will be an appeal to junior division or senior division or district, just as the case may be, on the basis of pecuniary jurisdiction. So this is an appeal. So against an appeal of a civil court, whether a second appeal will lie under 100 or whether it will be treated as a decree or it will be an order in terms of that provision, therefore it will be a revision. This is a critical issue.
Yes.
I think there is a judgment by my Lord Justice Debashish Barua. You find it out. He's sitting here, he has interpreted this provision. I think he has this second appeal. Monday.
also try to find out.
Please find out, na? Can you please find out? There is a judgment. I'll have a talk with him. I don't want to issue a notice without having a
Yes, yes.
satisfaction.
Absolutely.
Okay. So otherwise nothing is to be ordered. We'll take it up on Monday. Okay.
45 regulation also, I think they have used the word decree, but I will check that also.
That is, if it is a decree,
Yes,
then it will be a second appeal under 100.
yes.
So we can allow you to convert it to a second appeal. And generally, when it is condoned, dismissed on delay, second appeal we admit.
Yes.
And after notice is received, we allow it immediately. Anyway, we'll list this matter again on Monday. Please try to find out. I'll find it out. Keep these two things in my chamber, okay? Just keep it aside. Yes. What is this?
That is lordship.
Hmm.
Lordship, the petitioner before your lordship is challenging the order, infill order passed by the district consumer forum.
Now it will be an appeal against state consumer.
File appeal undertaking courtyard, but lordship, there is no appellate forum sitting in Arunachal.
No appellate forum.
Nothing, yet not appointed.
Okay,
This way, lordship.
Hard.
Having no alternative. point.
okay. Heard the learned counsel for the petition.
Yeah.
The present petition under okay, the present revision petition under 227 is filed. Order dated
27
order dated 27 to
2000.
where do we get it?
That is, yes, 125.
Order dated 28 to 2025 passed by the district consumer forum District Consumer Dispute Redressal Commission, within bracket DCDRC, Rowing, comma, Lower Dibang Valley, in consumer complaint number capital LDV, within bracket DCDRC, bracket close, capital CC/2/2024. Though an appeal, though the aforesaid order is an appealable order, however, it is submitted by the learned counsel for the petitioner that as at present, no appellate forum is there in the state of Arunachal Pradesh. Issue notice returnable after 4 weeks. Peruse the order passed by the learned consumer forum. Full stop. In the considered opinion of this court, proper procedure has not been followed while deciding the matter in as much as the conclusion or arrived at, it is in the prima facie view of this court that the conclusion arrived at is not based on any evidence. Accordingly, having a prima facie case, it is provided that till the returnable date, the impugned order at its shall remain suspended. Petitioner to issuance of notice within 5 days. Yes,
My lord, this is for quashing of the FIR.
where is that FIR?
Page number 15. Annexure 1. To the officer in charge police station Palin, Karadare district, Arunachal Pradesh. Subject submission of an FIR against Sri Gichik Tadak, Sri Gichik Taba, Sri Tagro Tamang Taso, and 16 others unknown person for illegally dismantling the suspension bridge and disconnection the existing GI5 line. Respected sir, it is pertinent to inform that from one reliable sources, we have came to knew that the Sri Gichik Tadak, Sri Gichik Tapa, Sri Tagro Tamang.
What I am not getting anything. This pipeline was stolen or what?
No, sir, this is
This
some
it's
work.
GI pipes?
No, sir, there's some water supply connectivity, Lordship, that some village road, Lordship. Lordship, the thing is, Lordship, the
This
FIR.
was missing.
Yes, Lordship. So, Lordship, here, Lordship, the FIR is against the petitioner
That
and the other
suspension
also.
Suspension bridge was dismantled.
Yes, Lordship.
And disconnection of existing GI pipeline.
Here, Lordship, against the petitioner and other persons are also Lordship in the FIR. But the present criminal petition.
Now,
Lordship-
what is your ground for enforcement?
Firstly, my lord, here, this case is arising out of completely land dispute matter. Before filing of this FIR, one land dispute right there. That is page
Land
number
dispute
17.
between whom?
Land dispute between me and the rival group, this complainant group. Page number 17. And the customary court has passed the order in favor of me. Thereafter, this FIR has been filed. And fact of the, my lord, the alleging missing of the GI5 is the custody of mine. And as per instruction from the PHC department. Because their water supply connectivity was there, but due to non-supply of water, the water was not running through the pipe.
Where is that decision?
Uh,
Whatever decision,
17, page number 17.
page number?
17. Declaration. Annexure 2, page number 17. Declaration letter. On this so and so. With the undersigned GVA and this do hereby declare that land dispute case between Sri so and so and Gichik Tadik, it is me, son of so and so, have been discussed thoroughly in the presence of 2 supervisors, 5 judges at village rowing under the Tali Circle, Karada district. During the final summary of the recording of both the parties, we observed that the land Gangtung, this place, belong to Sri Gichik Tadik, that is me. Hence, we unanimously one-sided declare that Yura Tadik, that is opponent party, has no right to take the said land in possession, and he is allowed to execute. This is completely in favor of me.
Now, what is this executive engineer?
The executive engineer instructed me to keep the safe custody of the GI5. Now here, opponent party, the rival group of me, lodged a complaint alleging that the GI5 has been stolen or missing. The actual right competent authority there,
Where is that this GI pipes were had given custody to you by the executive engineer? Where is that?
that in written form, there is no such written form. And page number 20, annex chart 4, here we communication letter. Many occasions we have a communication letter made before in between the
Heard Mr.
Titoro.
Peter, Learned Counsel for the petitioner, also heard MS Venture additional public proceeding. The present application is filed as saying the for requestment of Palin PS case number 22/2024 under section 303 BNS read with section 3 of PDPP Act 1984. It is the contention of the petitioner that the said affair is a result of abuse of process inasmuch as there was a civil dispute between the petitioner and the informant Sri Yura Tagung. As
Lordship,
regards
here, Lordship,
family-
only
family
one
member.
petition,
just-
other petition.
I'll come now. Tagung, and the said civil dispute was also determined in favor of the petitioner by the Keba. It is the further case of the petitioner that the alleged GI pipes were handed over to him by the assistant engineer, PhD and WS Division, Tali, Kradari district, Arunachal Pradesh. Accordingly, the Learned Counsel submits that this is absolute and abuse of the process process, and therefore such FIR is required to be first. Before proceeding further, this court would like to go through
Please,
the
Lady
case diary of Swenso Police Station, case number Swenso. You have already been granted bail.
Yes.
No problem. Accordingly, the Learned Additional Public according for the scan copies
Coffee.
of the case diary of Swenso case on the next date fixed. Please this matter on next Tuesday,
Yes, Lordship, next week, any date, Lordship.
next Wednesday.
Yes, Lordship.
We'll see on that day. What are the statements recorded of this?
Lordship. Like,
Yes, what is this?
This is an application for modification of the bare conditions line. As by the section.
Where is the bail order?
Page number 14, ma'am.
Page?
Page 15, ma'am. I am challenging the para 6, ma'am. I was granted.
We have been granted bail, but you don't have local surety.
So for that modification.
Okay. Heard the Learned Counsel for the application. No? The present application is filed for modification of a bail condition imposed by Learned Special Judge within bracket POCSO UPR in BA number 47/25-I in Itanagar WPS case number 57 of 2024, whereby a condition was imposed that. Where is that?
Para 6, ma'am.
A condition is imposed that petitioner shall furnish 2 sureties, out of which one of surety shall be from state of Arunachal Pradesh, inasmuch as it is the case of the petitioner that he is not a resident of state of Arunachal Pradesh, and therefore he is not in a position to fulfill such a condition. Accordingly, though he has granted bail, he is still inside custody since January 2025. The learned additional public prosecutor is put to notice, and he shall complete his instruction from the investigating officer.
Yes.
Just to have, without issuing a notice, we should not, any informant is here,
Yes, ma'am.
will he be not necessary?
No, my lord, this bail condition, this, I am.
Bail but POCSO,
Yes, but this is, my lord, bail, for modifying of bail condition. So there, it's not required of victim, I think, ma'am.
why not?
Because this is.
Ultimately, that order was
Already-
modified.
Last para, your lordship, of the bail conditions. In violation of any of the conditions of the bail granted to the accused, the bail will be
No, that's fine, that's
rejected.
fine, but Supreme Court has time and again said, don't impose such a condition which.
Yes, ma'am. I have case for me.
He was
Yeah.
getting bail on default
Huh?
default bail.
See
Yes.
his condition, he got a default bail. You are a default bail.
Yes, ma'am. This is January, ma'am, 18/1/2025.
Then if it is a default bail, where is the condition of giving a surety? Okay, we'll pass this order, give the judgments, but you should not pass an order on the without giving a notice to the public prosecutor.
Yes.
So that's why I put you notice, he can complete his instruction by the next day fix. List this matter again on. You have an instruction from your,
Obliged.
give the judgments. List this matter on
Friday, madam.
Friday?
Obliged.
Friday. What was the offense?
The offense is for cheating and forgery.
Huh?
For cheating and forgery, Lordship.
Cheating.
Yes.
But what kind of cheating?
No, the allegation is that the petitioner number 1 has distributed some genealogy documents of petition claiming to be a petition number 2, Lordship. This is a joint criminal petition, Lordship, as they have amicably settled the
Sir,
matter.
issuing a notice today?
Lordship.
Only order pass করেছো joint compromise. Yeah, pass yesterday orders. All for the scan copies. Okay?
Lordship, the proceeding may be stayed, Lordship.
Interim proceed. I passed yesterday orders. Good. Huh? After 4 weeks.
Scan copy of the TCR also.
Huh?
Scan copy of the
How
TCR.
have call it? Scan copies after 3 weeks.
Alright.
I passed orders yesterday.
Your Lordship, this matter may be passed over for some time because the main counsel for the respondent, Mr. G. Tarak, he is appearing in another court, Your Lordship. Deeply obliged.
May please, Lordship. This appeal is against the rejection of the injunction, my lord.
Appeal is against rejection of injunction.
Rejection of injunction. Very interestingly, my lord, there was an injunction order throughout from the beginning.
Hmm.
In the meantime, my lord, what happened after the WS was filed?
Hmm.
Initially, my lord, the measures indicate, my lord, the suit was for declaration of right title interest
Hmm.
and cancellation of a gift deed,
Hmm.
which was fraudulently executed by the plaintiff.
Hmm.
You know. Now, that and also for restraining the respondents, the defendants, from leasing out their property. What happened, my lord? This property was purchased by the plaintiff on 20/01/16, January 16. Thereafter, the defendant number 5 was the executive engineer of the tourism department, and he approached it that you should give this land for development of a tourist center here. No person who has purchased in January will give it the land for free. There
Yeah,
was an
give-
understanding
Give deed was
unregistered. Unregistered without any witness. That's a mandate. It has to be registered and a mandate.
Now your suit was for
Suit was for
cancellation of-
declaration cancellation gift deed,
Ah.
declaration of right title interest, and recovery of possession by demolishing the building that is constructed.
what is that building
That
constructed?
is a tourist center, tourism center. What the understanding given to the plaintiff was that if you give your land on donation to the government, which he purchased on January, and the gift deed is of June 16, 5 months thereafter. So in lieu of that gift, the tourism center, it will be leased out to him. He can run that tourism. A gift deed was executed, and the gift deed, there was a word used, mutual understanding. That was basically the mutual understanding. Subsequently, when the building was constructed, it was ready for possession, ready for leasing out. He submitted an application before this that you give me this, you have promised me this. The defendant number 5, who has made actually the promise, he has also agreed in the defendant in the written statement that yes, there was an understanding. We gave a promise that his leasing, he will be given a priority while giving the preference while giving the lease. There was no promise which to preference. The promise was
Now,
in
what
lieu.
is the status of the house as on date?
As on date, the building is constructed. We filed this suit. There was a status quo all along operating. In the written statement, they brought in that the lease deed has been executed, but that lease deed was for 1 year expired. Subsequently, this status quo continued. Meanwhile, the lesser member files an application before the court for modification of that status quo order.
He is a party respondent, part defendant in the suit.
Yes, the lessee.
No, let's see.
Lessee did not contest the suit.
Okay.
The lessee did not contest the suit. The lesser comes an application first, initially in the election time, with an application for modification of the status quo order and allowing them to use the premises for the election. It was granted. Subsequently, the status quo earlier given with regard to leasing out the property, it continued. In the meanwhile, by way of the WS, we came to know about this lease. We filed an application for amendment
To challenge the lease.
to challenge the lease.
Okay.
Along with that application, there was also one application filed by again the lesser, allowing them to use that premises for the period of Zero Music Festival for 4 days. We considered to that prayer. In that order, 19.9, the trial court modified the early status quo order to the extent of restraining not to hand over the possession to the lessee, the defendant number 6. That order continued. In view of this subsequent development and the amendment, my lord, I was required to file a new injunction application. That injunction application was filed on the date when this amendment.
Why you required to file a new injunction application?
Because my lord, the earlier injunction application was when there was on a premises that when there is no lease. Now there is an application filed for
But
amendment.
though
of the
there
suit.
is a lease, there is a no lessee was.
But not possessing. So therefore, for the purpose of that injunction, because my modification of that injunction was done in an application filed by the defendant number 1 to 4. Now that application on that day when it was allowed, it had got infractions. So though it was pending until further orders, on the next day this application would be become infructuous. So my injunction, which was modified, restraining them from handing over the possession, would go. In the meanwhile, I filed an application for extending that injunction.
What is the MP order? You
Madam,
switch for a tourism,
Sorry.
I'm for that.
acquired a land. You are a state.
My lord, although I am the standing counsel of tourism department, I didn't represent it in the lower court, my lord.
Maybe.
So I need some time.
What is the MP order?
My lord, page 171.
Page 171.
Interestingly, my lord, this application have not even got adjudicated, my lord. What it has been said, my lord,
Lordship,
You want an instruction?
yes, ma'am.
You complete your instruction. Monday we are taking this up.
By Monday.
Well, he got 1 month time, my lord. 15 days time for instruction. This is not a first day, my lord, it's coming up. On 9th also they took time, my lord, saying that.
Yes,
Monday, it may be taken because
if Monday or we will pass an order.
by Monday, I'll
Okay,
seek it.
the learned council for the, yes, course, Monday.
Come, you see, or on Wednesday having another matter is fixed.
So then we'll fix it on Wednesday.
Wednesday.
Wednesday. This again on Wednesday. The learned standing council for the tourism department shall complete his instruction by the next date fixed. Matter will be taken up on the said date.
In fact, I was suggesting that only because my injunction prayer has not even got adjudicated.
So earlier injunction will continue and.
And this
that-
press
that
injunction, because-
second, we'll dispose it of.
Yes.
What is the necessity of fighting it here?
Yes.
An injunction is continuing till day one. Prima facie, this gift deed is unregistered. Number one, even if it is unregistered, another aspect of the matter. To run for three options, nothing more.
Yes. Grateful, Lord.
My lord, my lord, this is bail application for granting of regular bail of at least accused person. My lord, I had moved bail application before
What is
special
the affair?
FIR page number 18.
18.
Yes.
Now, what is the present status? Case there is there?
No CDs. They did not wish.
The CD on record.
My lord, under section NDPS, Your Honor, is available, Your Honor. Only non-bailable section is 132 BNS, Your Honor. Only non-bailable section is 132 BNS.
What is 132? This is an NDPS.
Yes, my
No
lord.
NDPS registered.
No, NDPS is registered, but
Then-
that is valuable, and that is valuable section, Your Honor.
NDPS is available under what section this has been registered?
It is section 121, 21A and 27A, small a.
Small
This is,
quantity.
yes, consumer.
What is the quantity?
Quantity is in scissor is 0.12 gram.
So
Is-
0.12 gram is a
is-
small quantity.
Yes, below a small quantity, Your Honor.
But this is not available.
That is, NDPS section is valuable, but
Please
what,
to us where is NDPS section is available? NDPS Act. When can you produce the case diary?
Lordship, I was told that I was on leave, Lordship, till 5.
So when can you?
On 14, 13, 14.
14, okay.
Yes.
Learned, you are for special public safety. Additional
PP.
PP, learned public prosecutor. Praise for some time to list accordingly.
Yes. Obliged.
Yes.
May I please, Lordship? Lordship, I'm appearing on B. Jama, Lordship. Leading counsel B. Jama is unable to appear today, Lordship. Due to
Standing
some
council, why standing on?
leading counsel, Lordship B.
Leading
Jama.
council.
Yes.
A series there?
Yes, Lordship. On the strength of Lordship interim bail, they appeared before.
Okay,
So,
you
I-
want
I-
his custody?
Lordship.
What is the, where is the affair? Affair,
If-
affair, affair is a
FI
place
is at page number, Lordship.
11.
Yes, Lordship.
Medical report.
Medical report was not furnished since MLC report was this complainant exam.
Medical examination report of the accused are not there. Accordingly, matters stands adjourned and we listed.
Lordship, tomorrow, Lordship.
Not possible.
Listed
We'll
on-
go on the Monday, Lordship.
This Monday
This Monday.
or next Monday?
Next Monday, Lordship. Be it on 13, Lordship.
Huh? 13th. 13th.
It is a-
Interim order passed by lesson 13.
Yes, but Lordship here, applicant not come with clean and it appears, Lordship.
So allegations are very serious.
Yes, Lordship.
So if medical substantiates it,
Yes,
this is not a case for bail.
yes. Lordship. Definitely.
Paper book is ready, madam.
This matter.
Yes.
Item.
14, 15.
Okay.
14, 14.
This matter is ready for hearing. Paper book has also been prepared and served upon the learned counsel. Please this matter for hearing. In its own term. This is item number?
14.
What have you given? No, this is 15. 14 is a red file. That's it.
Yes. 15, my lord will recall it.
There could not have been better order than what was passed.
Yes.
What is the address?
They are not appearing, my lord.
None appears for the petitioner. Though Mr. Panging learned counsel for the petitioner is present. However, none appears for the respondent. Accordingly, matter stands adjourned in the interest of justice. List this matter again on, we'll give a try on next Thursday. Not this Thursday, next Thursday.
Wait, your lordship. Next.
Yes,
Almost a mercy application, lordship. It's a restoration application. So what had happened in this matter was on the first day, when the matter was fixed for returnable date, no date was given. And being outstation council's lordship,
where is the order of dismissal?
the last order lordship will find at page 17.
Notice has already been issued.
Yes, the others,
In name shown,
they appear on the last occasion, Lordship.
name shown today in the cause list.
Cause this I haven't seen, Lordship.
Hmm?
Name shown, Lordship. Yes, Lordship, name is shown.
This is an application. Where is your ground?
Page paragraph 4 and paragraph 5, Lordship.
Paragraph 4 and 5. Application for restoration of RFA number 03/2024 by recalling order dated 9/12/2024 passed by 9/12/2024 by which the first RFA was dismissed for non-prosecution. None appears to object the present application, nor any objection has been filed. No objection has been filed. It is contended by the learned counsel for the petitioner. Where is paragraph?
Paragraph 4, Lordship.
That both the advocates on record are outstation counsels and are from Guwahati. As no specific date was fixed on the first date, the
Page 13 is the order.
when the appeal was admitted, they could not be aware of the next date when the matter was dismissed. It is seen that the ground taken are for the for the fault of the learned counsel for the inadvertent mistake, not fault, inadvertent mistake
As Lordship
on
said.
the part of the learned counsel for the petitioners. Considering the explanation given and also considering that no objection has been filed, this court is also of the view that the grounds shown in the in the applications are sufficient to recall the order dated so and so. Accordingly, order dated 9/12/2024 passed in RFA number 03/2024 is hereby recalled. Registry to restore the regular second appeal number 03/2024 to its original file and list this matter for hearing on.
Date, Lordship.
That's right, hearing on.
Any date, Your Lordship.
You give a date. After two is give a date, let them also.
May 15th, I'll be here.
May 15th.
Yes, Your Lordship. Deeply obliged, Your Lordship.
Highest Miss Christian's disposal.
Deeply obliged.
Yes,
Lordship, service to respondent number 2 to 8 is still awaited.
second,
Yes, Lordship.
await service report in respect of respondent number 228 and list after 4 weeks on an with an updated office note.
Lordship, interim order is there.
Interim order pass earlier shall continue till the next date of proceeding.
Reminder to register
Hmm?
for this year.
Hmm?
For this year,
TCR required.
yeah, yes, Your
Any
Lordship.
direction was issued earlier?
Yes, this was called for. Registry maybe.
No, TCR is not called for. Okay, the registry to reissue reminder to the learned courts below for the TCR for production of TCR, scan copies of TCR as directed by this court
Yes.
earlier on 12/3/2025.
Obligation.
Mr. Lee Majumdar is on legs on the other court.
We have finished our list.
Yes, that is.
When?
Let me just consult my senior regarding the date and I'll inform you.
Will not come back at 2.
Oh, we can come back at here as your
Yes,
lordship
Vicky, what you
directs.
say?
I have an interim order in my favor.
Okay. On the prayer of the learned counsel for the respondent, list this matter again on, keep the gap They will inform me. Okay. Interim order is already until further order?
My lord, I'm sorry, my lord.
Interim order passed earlier.
1 years.
Till this point. Okay.
Your lordship, is your lordship sitting in the second half? Will your lordship be sitting?
No, no.
Okay.
We will not come for this matter again.
Yes.
Last matter is there now. Give after 2 weeks. Give a date after 2 weeks, huh? Yes. What is this?
Lordship, I have filed a CRP
Hmm.
against the impugn order, that is page number 108.
108.
This is the
What is this?
Lordship, this is the order passed by the below appellate court, that is a district court, Pasigat.
No, this is the impugn order 11 to 2025.
Yes, correct.
And what is this?
Lordship, that is an additional affidavit. Today I have filed an additional affidavit.
No, this will have to come to record, not like this. This is just, you have called it. No, here's you.
Yes, I have.
No,
filed-
no, no, you cannot, I cannot accept like this. It will have to, you have filed it.
Yes, I have already filed. It has come from the registry.
Which has come from the registry.
Yes,
Okay,
ma'am.
then fine.
Yes,
Then fine.
there is an Lordship additional affidavit.
No, what was the issue?
Lordship, the issue, the fact of the case is that, Lordship, the petitioner is in possession of a plot of land measuring about,
Now, this was an order, appellate order,
yes, Lordship.
appellate order.
Lordship.
Now, it is under 15(2) of the Arunachal Pradesh
Lordship.
Civil Codes Act.
Lordship,
Now, that's why I fixed the matter when on Monday, item number 1 was fixed when? On Monday. Huh? Monday. Now, just tell us whether an appellate order, there will be a second appeal or a revision to 27. We'll go to merit later on.
Lordship.
See, under 15(2),
It talks about the order and decree of a original suit. Yes, Lordship.
original suit.
The original suit, but here in this case, he has challenged, the fact of the case is that I have a plot of land measuring about 16,000 square meter, which was purportedly disputed. And accordingly, Lordship, a KEBA has been conducted. And KEBA was conducted, and on 22/10/2024, KEBA has passed ex parte order against me since I have not appeared. With a reason, I have not appeared.
Maybe
Yes,
it is
yes.
an expert order.
Yes, Lordship. Thereapter, what happened is that I have challenged the impugn KEBA decision
Before?
before the civil judge senior division of the concerned application.
Okay.
And in that KEBA order, in that appeal order, the status quo order has been passed. Only status quo order has been passed to the effect that both the parties shall refrain
Magistrate.
from constructing or doing any activities in the suit land. Thereafter, my appeal has been admitted, and during the pendency
That is
of-
by the junior division.
yes, yes.
Then
Again, that same order has been again challenged by the respondent before the district judge under
that
section.
status quo order,
Yes, yes.
not the main order.
Not the main order.
Okay, status quo order was challenged before the
This district judge.
district judge. Now,
Yes, under Lordship, under
Order,
16-2.
okay, under 16.
16-2 of Arunachal Pradesh, Civil Court Act.
Act, okay.
Lordship, may I read
No,
the,
just tell me the story then, that what happened ultimately, appellate court status quo was vacated.
yes, vacated.
Now, what is the present position?
Against that vacation order, I have came before this honorable court for filing writ,
227.
yes, 227,
Okay.
CRP.
Okay, fine.
Yes, that
So it's not the original order, but the subsequent order passed in injunction petition.
Yes, that is an, Lordship, that is an appellate order of
Hmm.
the court, because the main order was passed by the KEBA. Again, KEBA has been stayed by appellate court, that is.
Now, what is the present status?
Present status is, status code is being maintained.
Still planning.
Yes.
We'll take up this matter on Monday.
My lord, I'm not on the merit, I'm on the maintainability, we are raising the maintainability of the 227.
That will come. So we are fixing the matter on Monday.
Yes, my lord, because we are agreed by this order, because as on that, because of the status quo, we are not able to enter into our land.
We'll do, we are doing that, we are taking this matter on Monday. Okay?
My lord, kindly see the
We
maintainability
will
of.
take it this matter on Monday.
Lordship.
Can't you wait till 3 days? Where is the guarantee that I will pass in favor of order in favor? See, here is an issue that order is a kind of injunction order,
Lordship.
not the main appeal. Main appeal is still pending.
Lordship.
This was an interlocutory order which was challenged before the district judge. Now district judge vacated, we in a civil court kind of thing, we said that injunction was vacated, status order was vacated. Against that, he has this. According to you, what should be, it should be a second appeal.
My lord, against the order, we are challenging the order again, it is the appeal against the order passed by the civil judge senior division. Against the order passed by the junior division, the appeal is filed under civil judge senior division. And against the order passed by the
It will be the district judge.
district judge or the high court, as the case may be.
Ah.
So here in this case, we are challenging, appeal is filed against the order passed by the civil judge senior division. It was after the Kevang, in the Kevang ex parte, Kevang was decided in my favor. Thereafter, apprehending that they will challenge the said order, I have filed the caveat application.
Without hearing you,
Without hearing the status quo.
Anyway, we understand that. Issue is that status order was passed without hearing you. So you preferred an appeal before the district and session judge.
Yes,
That see, without hearing me, this status quo order is passed.
yes.
Now district judge passes in your favor. Isn't it?
Yes.
Now the appeal remains, main case remains. Main case remains. Now you will have to decide whether it will be an 227 or any other applications. Is that it? This is your case, that this is not maintainable. Against this, what will lie?
My lord, my humble submission is that this, whether the appeal under 15(2) of the Civil Code Act 2021, whether it will be appeal or it is maintainable or not maintainable, it will be decided by it can be agitated before the learned district and session court. Because as on now, they have come before this honorable court under 227.
No. This order is passed by district and session judge.
Yes.
So against district and session judge, what will be his remedy?
He should appear there and contest the case.
Huh?
Because
His remedy will be High Court only.
Yes.
Whether it is a second appeal or a revision, that will be different. But when an order is passed by an appellate, and this order passed by the district and session judge is not touching the original case
Yes.
filed before the senior division.
Lordship.
It is basically only relatable to the injunction order passed. Now, therefore, we want to fix it on Monday. Monday, we have fixed another matter touching this subject. Then we will hear you. Okay?
meantime,
Lordship,
my
in the
lord,
meantime, I have.
Meantime, what?
in the meantime, that earlier order it only put a returnable debt, that may not be extended.
Then what will
because-
remain in this case?
Because
And
there
also
is
they have not even filed their reply.
What will
No-
remain?
no
in this-
reply is
No
required.
reply is required. No reply. What will remain in this case till Monday?
My lord, we have to collect the vegetable because they are on the verge of decay and waste.
Monday. Monday. Today is
Tuesday.
Tuesday.
Yes, Tuesday,
To
Wednesday.
Wednesday. Today is Wednesday. Thursday and Fridays. Saturday, Sunday, otherwise holidays. Monday we will decide matter along with the other matter. Okay? List this matter again on Monday. We'll decide this matter.
Till then, Lordship is status quo.
The interim order,
That-
Australia
yes.
will continue till the next date of listing.
My lord, last opportunity maybe. Next time also they may take time.
Sir, I am interested to decide this matter. I want to learn something.
Lordship, I am not seeking time.
No, he's not seeking time. Time is, I am giving him time because I have fixed another matter on that day. Same exercise will be done on the same day.
Lordship.
Okay. Yes.
My pleasure, Lordship.
Mm.
My lord, this is the one of the shortest NIT issued by the respondent department. Just for my lord, one day only, my lord, technically speaking, my lord. Had
What is the present status?
The work already started. Otherwise also, my lord, in this writ petition, the petitioner have not received how it affects him.
How it affects means if you give one day time, how the other will participate.
Yes,
can be done.
even in as per this,
Notice is issued to the private respondent.
not.
No, my lord. On several occasions, my lord, this matter is.
You want to say you have already awarded the contract.
Contract and now work has been started. It's a
No private, my lord.
construction of school building, my lords.
That we understand, you have not made any private party.
No, ma'am. So, my lord, the shortest notice, one day only. So therefore, my lord, the all notice, my lord, in respect of the all worker has to go, my lord. That's because, my lord. by
What is
this
the present status of the work? When work order was issued?
Work order, that part,
That is very vital.
yes.
See, apparently I have seen it's not fair.
Then let it be tomorrow. I'll produce that. But they have instructed me that
Huh?
they,
You have, we are fixing it day after tomorrow.
okay.
You have two instructions. One is whether any work awardee work is issued, and if issued, what is the present status of the work?
Yes.
Oh.
Yes.
The present application under Article 226 of the Constitution of India is filed assailing a tender notice. Where is that?
Page 17.
Page 17.
Yes, ma'am. 12 March 2023.
Then press notice dated 12/3/2025, isn't it?
Yes.
2023, whereby
25.
Executive Engineer Rural Works Department Sagali invited tenders, invited item rate tender from eligible contractors for construction of certain, for execution of certain works. Full stop. The bids were made available. Notice was issued on 12/3/2025. The bids were made available with effect from 13 to 15/3/2025. That is on work has already been awarded. Pursuant to work in question has already been awarded pursuant to the tender notice. accordingly, he shall produce the award and also complete his instruction as regards the status of execution of the work in question. Release this matter tomorrow.
Yeah.
Tomorrow.
Long list.
Yes, Mr. Mozumdar, we have adjourned your matter.
My lord, yes, my lord, they are actually, I can be taken about 2 o'clock today, my lord. Issue is
Somehow. The purpose for which we visit here, those are there.
there are various parts of it. Then we'll have it after 2 weeks.
I'll give a date, that's why I'm saying.
Otherwise, my lord, next week your lordship is here, my lord. Issue is like this.
No issue. We have given it after 2 weeks.
All right. Sometimes
Sometimes,
I have to bow down.
sometimes also we need
All right.
some space. Yes.
After 2 weeks. If
Item 19 अभी जो adjourn किया था, वो हाँ 2 weeks और 15 आज 30th तो 2 weeks के बाद 14 में 2 weeks हो जाएगा. नहीं हाँ 15. Thank you.